Hi friend, welcome to the company law adjudication and appeal series. Today we are discussing Delhi adjudication order for the violation of section 149 subsection 1 of the Companies Act, that is the non-appointment of the women director as per requirement of the section 149 subsection 1. Let's see the legal provision of section 149, that is the legal requirement for appointment of the women director of a company. As per the section 149, every company shall have a board of directors consisting of individual director and shall have minimum number of 3 directors in case of public company, 2 directors in case of private company, and maximum 15 directors. And second proviso says that such class or classes of the company as may be prescribed shall have at least one woman director. And here prescribed as per the rule 3 of the company's appointment and qualification of director rules 2014, the following class of companies shall appoint at least one woman director: every listed company, every other public company having paid up share capital of 100 crore rupees or more, or turnover of 300 crore rupees or more, provided that a company which has been incorporated under this act and is covered under the provision of the second proviso to subsection 1 of section 149 shall comply with such provision within a period of 6 months from the date of its incorporation, and provided further that any intermittent vacancy of a woman director shall be filled up by the board at least the earliest but no later than immediate next board meeting, or 3 months from the date of such vacancy, whichever is the later. And in explanation, it said the paid up share capital or turnover, as the case may, as on the last date of the latest audited financial statement, shall be taken into account. Let's see facts of the case. Company having registered office in at Delhi, and as per the facts of the case, the company financial statement as filed by the company is paid up share capital and turnover as on 31st March 2021. Turnover is the nil and paid up capital is the 1082 crore, that is the paid up capital, and date given in the auditor report is the 14th September 2021, and the company is clearly required to appoint a woman director based on rule 3 of the company appointment and qualification of director rules 2014, as the paid up share capital of the company is more than 100 crore, and a so-called notice was issued to a company and officer in default on 2nd August 2022. In this regard, the company, while later dated 10th August 2022, has submitted its reply, and an opportunity of personal hearing was given to director and authorized representative to appear before the authority and made submission on behalf of the company. Here, penalty provision for the violation, non-compliance of the section 149 read with the rule 3 of the company's appointment and qualification of director rules would give rise to liability under section 172, which read as per section 172, if a company is in default in complying with any of the provision of this chapter, and for which no specific penalty or punishment is provided therein, the company and every officer of the company who is in default shall be liable to a penalty of the 50,000, and in case of continuing failure, with a further penalty of 500 rupees for each day during which such failure continues, subject to a maximum of the 3 lakh rupees in case of a company and 1 lakh rupees in case of an officer who is default. In adjudication, it is evident that the company has not complied the provision of appointment of the woman director. However, in its defense, the company submitted its letter, and during personal hearing through the authorized representative has submitted the proposal for appointment for women director in the company was forwarded by the company to NHAI, which hold 100% equity in the subject company. As per the clause 84A of the Articles of Association of the company, all the directors of the company are required to appointed by the NHAI only. It was also submitted that the officers of the company took steps for the appointment of women director in terms of the clause 84A of the articles, and that no action may be taken against director or KMP of the company. Under section 172, penalties leviable on the company and officer in default. In the present case, officers of the company are not in a position to take remedial action to rectify the default. Therefore, it may not be appropriate to regard them as officer in default, and also any direction issued under section 454 section 3b would not be fruitful, as such officers are on their own not in a position to rectify the default. However, the default in respect of the company would lie. As per the explanation to Rule 3 of the Company Appointment and Qualification of Director Rules 2014, the paid up capital is being reckoned from the next date of the latest audited financial statement, that is one day after 14th September 2021, that is the date of the auditor report, and the period of the default would continue till the issue of so-called notice. That is 2nd August 2022. This period is referred as the default period. Therefore, the default period is 322 days. And according to the calculation of penalty as on the company, there is for the number of the days of the default, 322 days. Initial penalty is 50,000, and penalty for continued default, that is the 1,61,000. There is a total penalty imposed on the company 2,11,000. And in order, company is directed to comply, directed to pay the penalty amount as per given table, and the company is directed to rectify the default immediately from the date of the receipt of the copy of this order. The notices shall pay the said amount of the penalty through online by using the MC website. Appeal, if any, prefer against this order may be filed with the RD within the 60 days from the date of receipt of the order in prescribed form ADJ, setting for the ground of appeal, and shall accompany by certified copy of the order. Thank you so much for watching this update. You may refer original adjudication order copy from the MC website, and if you needed this adjudication order, you may also SMS or mail, drop your mail. Thank you so much for watching this update.